of the accommodating the First Nations in the area where the rivers, the more sacred portions of the property,
Well,
close to the rivers, the two rivers. I'm aware of it, that the whole property is of cultural and historic significance, and that's why I kept on mentioning it earlier, so that we don't have to go into a debate about the historical and cultural significance and the tangible and intangible resource value, heritage value of the property. The proposal with regard to the river, the area immediate, the sacred ground immediately surrounding the rivers, is that not acceptable to the applicant? And I'm not talking about the construction of the buildings, I'm only talking about the river, the area of the river that is envisaged to accommodate the First Nations and enhance, according to the respondents, the cultural and historic significance of the river area.
Lady, obviously, from their perspective, the correct river to rehabilitate is the original river, along the original course. That is being infilled, so that is certainly not acceptable. And whilst I can imagine, I don't have specific instructions on it, whilst I can imagine it would be preferable for the canal to be given riverine banks instead of concrete walls, the preference is that the original site of the river is the one that is improved.
And as we sit here today, if the court is against the applicant, there would be no way to rescue the river from possible, I don't even want to use the word concrete, but in any event, from being damaged as a result. I'm using the word damage in inverted commas. If the court is against the applicant, the river will then be damaged beyond.
Lady, the development isn't the only opportunity of rehabilitating the site.
Yeah.
If your ladyship has regard to Section 46 of the National Heritage Resource Act, it specifically provides for expropriation of land for purposes of conservation of the heritage resources. So if one is opposed to the development, one isn't advocating automatically for the retention of the golf course and the South African Railways and Harbours Recreation Club buildings. It's perfectly compatible with not proceeding with the development, for it to be declared a World Heritage Site, for funding, for the land to be expropriated, for public funds to be used, or possibly international funding to be used, to be able to properly recognise and acknowledge the site. One must remember, my lady, the indigenous people of this country, the First Nation people, have been completely chased off virtually all of their land with no compensation. They did not benefit from the constitutional negotiation process. Section 25(7) has a cut of the Constitution, which provides for land claims, has a cut-off of the 19th of June 1913. They were excluded from that process. This is one of the last vestiges of what could be something that's recreated to the universe as they knew and understood it at that time. And the universe as they knew and understood it at that time could never contemplate a massive commercial development in the middle of it. And those opportunities have essentially just about completely disappeared. And that's why it's so deeply important to them. If one has regard to the fact that the San and the Khoi have no opportunity for restitution, have no opportunity for claiming compensation for what was taken from them, all that they have left to rely on is Section 30 and Section 31 of the Constitution, read together with Section 9 and the prohibition on unfair discrimination.
Were those submissions made in the founding papers in terms of those constitutional provisions, or was it raised belatedly?
If I'm understanding your question correctly, my lady, I think I've already dealt with that issue. We say that effectively those rights were invoked through complying with the principle of subsidiarity and pleading a case in relation to the NHRA, which is legislation that in part gives right effect to the fundamental cultural rights in Section 30 and 31 of the Constitution. Lady, if I can then come back to the review component, as it were, of the case, which I was dealing with at page 19, paragraph 43.
Can you just pause
and-
one moment? I'm just checking my notes. I note that the city says that the First Nations collective and the developer proposed several features after consultation, commemorative features.
Sorry, I'm struggling to hear you. Milady.
The First Nations collective and the developer, they identified certain features to commemorate the cultural and
Indeed, Milady.
historic significance of the property. It includes an indigenous garden for use by the First Nation, a cultural heritage and media center, an amphitheater for cultural performances, commemoration initiatives, and a heritage eco trail. The indigenous garden will allow the First Nations knowledge of food and medicine to be put into practice, and the cultural heritage and media center will allow their history to be recorded and taught. The heritage eco trail will align with the indigenous respect for the site's ecology and allow pedestrians to experience that ecology on foot. The garden and amphitheater will allow for various modes of expression. All these features will enhance the property's heritage. In this regard, the First Nation collective is satisfied with the extent to which the proposed development incorporates heritage resources which are currently not accommodated at the River Club site. And I'm quoting this in order to weigh the issue of apprehension of harm. How does the applicant view these features that is intended to be accommodated in the proposed development? Is it insufficient?
Well, in the first instance, it comes from a flawed consultation process from which they were effectively excluded.
I see.
So the opportunity of anybody other than a group that joined the Western Cape First Nation Collective had no opportunity whatsoever to influence that outcome. So it's flawed in that respect from a start. Number two, it forms part of a process that, if one scrutinizes it, was fundamentally flawed. It's the product of an unlawful approval process because of the deficiencies, manifest deficiencies that were never fixed in terms of Section 38(3). Viewed from the perspective of people who have a relationship with the land and with nature, effectively putting it in a can and creating museum-like minor reminders of it is a very, very poor second to restoring the land to as close as possible to its natural state and declaring it as a heritage site which truly acknowledges what that heritage is. If one looks, for example, at Mr. Jenkins' affidavit, he describes what the significance of that land, in fact, means to him and to the second applicant. So, if your ladyship will just bear with me. In fact, I quote it in the notes. If your ladyship will give me a second.
Can you just pause for a moment, because I'm going to lose my thought process here, my track of thought. The words that I was looking for in my notes were that the applicants contend that the conditions imposed for the development is mere window dressing. That's what the applicant is saying. And the First Nations collective support is a product of manufactured consent. Is that what the applicant is alluding to when the applicant says that the whole consultation process was flawed? Were the First Nations manipulated, or were they negotiating from a weak, from a perspective where they did not really have much of a say in the project?
Well, they've obviously formed an alliance with the developer.
They did.
Which gave them an advantage, but that's not the way in which you conduct a consultation.
It gave them an advantage. The First Nations collective. Oh, it gave them an advantage. What would the advantage be? Are you saying that the First Nations collective was just a group that was just being manipulated by the developer and was not really negotiating from a position of strength? I think that is what I was trying to say earlier on. But in fact, they just had to accept everything. The input was, as it's put here, mere window dressing. The developer is just creating this impression of consultation, and perhaps I must say the respondents, it's just all a farce. Because when I saw the words there, I paused for a moment to think about it, because if a group is just manipulated and forced to negotiate from a very weak position and just agree to something that would be detrimental to their cultural and historical heritage, it is something to be concerned about. The court should be concerned about if that is the case.
Lady, as I read the papers, there hasn't been a discussion of the relative bargaining power of the parties within that discussion. And there, with respect, doesn't need to be, because if one looks carefully and analyzes the prior consultation process, it was flawed. And that on its own, that flawed consultation process, means that there was non-compliance with Section 38(3)(e) or F. I can't remember immediately which of the two it is. The specific provision that requires consultation.
Yeah, we're looking at 38(3) and 38(8). Yeah. So it was flawed. The court will hear what the respondents have to say about that.
Indeed,
but
lady,
from the applicant's perspective, it was flawed.
I'm hoping that at some stage I can develop my argument around
sure.
that.
No, I'm just pausing here because manufactured consent, what does that mean?
Lady, I don't have an immediate, if there's a place in the papers where I can...
It means that the First Nations were manipulated, and their input was just mere window dressing. Ultimately, the developers, the developers influenced the decision. The developers negotiated from a position of strength, overpowered the First Nations, and literally forced them into supporting this project. Is my understanding correct that those are the applicant's assertions, which encompasses the flawed process?
Lady, as I read the case, we haven't explored the nature of the relationship between those, except also to raise the fact that a payment was made. We picked up from the answering affidavits that a substantial payment was made from the developers to the attorneys for the collective. That suggests that already there are issues that ought to have been answered that weren't, as far as that's concerned. But we don't even, with respect as far as the review is concerned, need to go there. We don't need to get to that stage, because the consultation process in it was fundamentally flawed. And it was flawed, first of all, because of the inception that I drew to your lady's attention, where to be able to be part of the consultation, you had to join a particular group. It was flawed because the person who was leading the discussion was one of the people who was meant to be being consulted, not Mr. Orenser. And it then gets worse and worse and worse as one goes through the report. The worst part of it is where reference is made to the diary of Jan van Riebeeck as a way of effectively trying to delegitimize in that report the second applicant, the Gorinhaicona. And he refers to an archive from Jan van Riebeeck's diary. And if I could just perhaps read that, if you will give me a moment.
Is delegitimize the correct word? It sounds a little bit offensive.
Well, delegitimize is putting it softly, lady. It really does go on the offensive, but if you'll just give me a moment. Unfortunately, because I haven't been able to work my way through my argument,
I will give you an opportunity now because I've got another issue that I need to raise before I'm going to allow you
I'm
to
battling to
proceed.
find the references.
Delegitimize, so that sounds very concerning. If
Well,
the
and
word-
that's why I'd like to, if you'll give me a
Yes.
moment, I'd like to get the reference and read it to you. So he refers at page 1108. And this is meant to be a report on consultation, but suddenly we go at section C into indigenous resistance to colonial settlement, 1652 to 1677. Groups at the Cape at the time of Jan van Riebeeck. On his arrival at the Cape in 1652, Jan van Riebeeck encountered and had various dealings with the indigenous groups, particularly the Peninsula Khoi, the Gorinhaicona, and the Gorinhaicona. There was also the Gorinhaicona, whom van Riebeeck describes in a memorandum as for information and guidance over successors at Wagenaar, and then includes the following gratuitous extracts from his diary. The Gorinhaiconas, of whom Harry has been usually called the captain, these are struntloopers or fishers who are exclusive of women and children not above 18 men in number, supporting themselves without the least livestock of any description by fishing from the rocks along the coast, thus furnishing a great accommodation to the company's people and free men, and so on. Then goes on to describe what they do by way of when they are employed domestically. And then in the second one, it gets worse. It says the Gorinhaiconas subsist in a great measure by begging and stealing. Among this ugly Hottentoot race, there is yet another sort called Gorinhaiconas, whose chief or captain named Harry has been dead for the last 3 years. These we have daily in our sight and about our ears, within and without the fort, as they possess no cattle whatever, but are struntloopers, living by fishing from the rocks. They were at first on my arrival not more than 30 in number, but they have since procured some addition to their numbers from similar rabble out of the interior. And they now constitute a gang, including women and children, of 70, 80 or more. They make shift for themselves by night close by in little hovels in the sandhills. In the daytime, however, you may see some of the sluggards, there's then a word I can't read, helping to scour, wash, chop wood, fetch water, or herd sheep for our burghers, or boiling a pot of rice for some of the soldiers. But they will never set hand to any work, or put one foot before another, until you have promised to give them a good quantity of tobacco or food or drink. Others of the lazy crew, who are much worse still, and are not to be induced to perform any work whatever, live by begging, or seek a subsistence by stealing and robbing on the common highways, particularly when they are those frequented by novices. So why in a report on an engagement and consultation process do you include blatantly racist material which is aimed at delegitimizing one of the parties? That's precisely what he's attempting to do here. And having done that, he then goes on to say that it is the Gorinhaicona who own the narrative. Only they can speak. And only they are recognized as the people who can legitimately say what the history of the area is. And then it talks about them, something along the lines of capturing the narrative. And from there it goes on to a justification of the project. Now, a consultation process that was openly racist, the report that refers to it as racist, can never by any stretch of the imagination be constitutionally compliant. A consultation process which treated one of the groups who were meant to be consulted in that way is not going to pass constitutional muster. So on that basis alone, there was a complete failure by the heritage impact assessment practitioners to comply with that particular provision. But as we set out in the notes to the oral argument, not one of those conditions was in fact complied with. And again, I'm hoping that I can demonstrate that to your ladyship by building the argument.
Yes, if you can just pause for a moment, just digress. I should have raised it earlier. After you respond to this question, I will allow you to proceed with your submissions. But when I looked at the chronology, of this matter, I was a bit concerned that the applicants took so long to launch this application. And I'd like to establish from the applicant, when I look at the approvals that were granted, land use, environmental approval, no action was taken at that time. But the applicant gave some explanation, and thereafter there was the issue with regard to the water use. And still the applicants didn't take. Oh, wait, I think the applicants did take action after the water use were revived, the water use consent. My question to the applicant is, the applicant went to consult the HWC. Let me just check my notes in June, I think. Just trying to get the date there. 14th of June, 2021. Applicants and their legal representative participated in an online meeting with the HWC. I'd like to know, did the applicant just adopt a supine approach with regard to this action, as alluded to by the respondents? We had land use was, consent was given for land use, consent for environmental use. The water issue was probably the last issue, the last consent that they needed, although there was an appeal pending. And then that sort of triggered the applicant, the first respondent actually could then proceed with the project, notwithstanding this appeal process in relation to the water issue. My question is my understanding correct? I need the applicant to assist the court here. Did the applicant launch this proceedings after they realized that HWC was not going to take action after that meeting?
Sorry, after they realized that?
14 June 2021, the applicants had a meeting with HWC. Yes. And we know what transpired at that meeting. HWC said, we are not getting involved, we are not taking any decisions on review. Did the applicant wait on the HWC to take action and then realize, and I'm posing it because I read the chronology, it's actually a very long chronology in terms of dates, so I don't want to go before land use, environmental use, water issue, online meeting. You just see the water, you just check my notes. 10 June 2021, OCA received the applicant received notification from the department that the water license was issued. 10 June, water license was issued, applicant became aware of it. 14 June, they have a meeting with HWC, and they were advised HWC does not intend to take any enforcement action and would also not oppose or institute any review proceedings in respect of the authorization granted to the developer, and more specifically the environmental authorization. Why did the applicant take so long to actually bring this application? I should have raised it earlier, but I think the applicant just needs to deal with that. The applicants need to deal with that before the applicants continue. The respondents are saying that the applicants created their own urgency in this matter. Self-created urgency by taking so long to institute action. The water license were issued, and then the developer started to commence construction, which is still, my understanding is that it's still at the early stages of development. Should the applicant not have taken action earlier?
Lady, first if I can just give the references, there's a full blow-by-blow chronology that's set out in the replying affidavit from page 2602 through to page 2606 that explains each step of the way how they were dealing with the matter. But if one takes a step back for a moment, Pudger gives one 180 days to bring a review. That is what the legislature has specified as the ballpark time period within which review proceedings must be brought. They were well within the 180-day period. This is not a case where one is
Was
seeking...
it 160 days?
I beg your pardon?
Yeah, how long did they take? Was it 160 days? I'm not sure.
Well, it depends what you look at, my lady. If
But they're within their time. I get what you're saying from that.
They were in
yes.
time, number one. Number two...
180 days after which decision?
But number two, there was no point in bringing 2 review applications.
But you could have blocked the development at any stage, even after the first decision was taken.
Well, the immediate response would have been, why are you coming here prematurely? Because you've got an alternative remedy, which is to oppose the planning permission. Why come with your
Which
review
the
now?
applicant did and lost on appeal. And then the applicant still did not take action.
Well, bear in mind, my lady, that they sensibly went to the Heritage Western Cape and said, please will you intervene? You're the body who's got primary responsibility. That was a perfectly responsible thing to do. When they weren't willing to do so, they had to get a review application ready. What kind of a review application was it? A review application that covers effectively 5 centuries of history. The review application that covers multiple different reports, multiple different planning decisions.
Did the applicant create their own urgency in this matter?
No, my lady. It's set out in the chronology. They took reasonable steps at every point to get the matter ready. And the other difficulty that they would have faced is this. There was no urgency until the water use license suspension had been lifted by the minister. There was no urgency. A party opposing it would have been entitled to say, what are you coming here for? What is the irreparable harm? What is the irreparable harm that you face? Because it's suspended. You put in a water use license appeal, and it has the effect of suspending it, number one. Number two, construction hasn't started. Where is your irreparable harm?
So 7 July, the first applicant was informed by the Department of Water and Sanitation that they submitted a request to the minister in terms of section 482A. Let me see. Oh, notwithstanding the appeal, this request was made. I'm just checking the dates. 26 July, that OCJ's attorneys were advised. Okay. 26 July, the first applicant's attorneys were advised that the water use license had been brought into operation by the minister and that construction commenced on 26 July. When did the applicants launch this application?
On the 2nd of August, ma'am.
2nd of August.
It's a matter
So
of
the applicant is using the water license as the trigger for this application.
Well, it was effectively the trigger because then there was no longer any statutory inhibition on the commencement of the developments, and they came within 7 days of that.
Wouldn't the land use and the environmental authorizations not have been a more appropriate trigger?
No, my lady, certainly not for urgent proceedings. For a review, yes, but a review you have 180 days to do it. What triggers the urgency is when the minister lifts the suspension and when the construction starts. And then they moved within days, my lady. And that's with respect, my lady, there's a whole initial part of my argument that I've left out. And that was to try and, with respect, urge upon your ladyship that there is a joining of forces, a clamoring and a joining of forces by the respondents. The developers siding, the state respondents. State respondents are the regulators here. Regulators are meant to stand as relatively neutral parties between the citizens and the stakeholders on the one hand and the developers on the other. This under-resourced applicants Second applicant, marginalized in society, marginalized in the decision-making process here, treated with complete disdain, vilified.
I'm aware that the applicant had funding issues and needed to mobilize themselves, etc. I've taken note of those submissions that
Indeed,
were
Milady,
made.
but I'm making a different point, Milady.
Yes.
Trying to make a different
Yeah, well, you're saying
point.
second applicant was marginalized and you were busy criticizing the developer and the city and alluding to the fact that they joined forces in this matter.
The point I'm trying to make, Milady, is that there is a loud clamoring from 4 different respondents about delay and urgency and so on. With respect, it's not founded, but the problem in proceedings like this, where you have well-resourced groups against under-resourced groups, is they can be drowned out.
But isn't the court's role not to allow that? And that's why
Indeed,
the court is
Milady.
engaging you on it. You didn't raise it, but the court read the papers and noted even the 8th respondent, let me see, yeah, 8th respondent gave some chronology and also touched on those aspects. And I note that the applicant didn't really deal that much with it.
Indeed,
But
Milady.
is it an important aspect or not? The fact that the respondents are saying the applicant was literally the applicants were folding their arms. Land use was granted, environmental use was granted, water license, only by the water license. Let me just check the dates. Let me just check my notes.
If you have a look at page 2606 of the report.
Sorry, I'm just consulting my own notes here. The application for environmental authorization was 19 December 2019. 20 August 2020, the provincial director, that's 4th respondent, issued the environmental authorization. 20 August 2020 already.
Sorry,
20 August 2020, environmental authorization for the development was granted. So I'm looking at the chronology and the timeline here.
Indeed, Milady, but that would have been before the appeals.
Yeah.
And obviously, they exhausted their internal remedy. They brought appeals. They were compliant in that regard.
Applicant appeal 22 Feb 2021. Let's see. Oh, sorry. Yeah, they appealed, and then on 23 Feb, the appeal was considered. And the city's planning and appeals advisory panel recommended the appeals be dismissed. So yeah, I've got the chronology, I have the timeline, and the applicant is saying that there's no merit in the respondents' submissions, that the applicants literally dragged their feet, and that there is so much at stake in this case, and that is the second issue that I'd like you to respond to before the court allows you to proceed. This is a very important case, and if we need to come back on Saturday morning, we can come back to court. But it's important for the court to engage the applicant and to give the applicant an adequate opportunity to deal with the concerns raised by the court. Did the applicant wait on Heritage Western Cape to actually pursue this application and decided we're going to take a back seat until such time maybe HWC will take action? Or did they take action before they went to HWC?
Lady, it was appropriate to see, with respect to see with the Heritage Western Cape, a state body, they should have decent resources.
But at that stage, no action was instituted yet, if my memory serves me correctly.
At that stage?
The action was instituted after the HWC online meeting, when the respondents were informed that HWC was not going to take any action. So I'm just raising the court's concern with you so that you can give the court an explanation. Why only after that meeting did the applicant then decide to take action?
Sorry, why do we?
The applicant is aware of the respondent's submissions in this regard, and the court is just engaging the applicant with regard to the delay in launching this application. Yes. Is the water use authorization, the date that the applicant is relying on in terms of the 180 days?
Well, it's the date that effectively lost them any protection against the commencement of the development. But obviously they had been working already at that stage on preparing a review application, and it was a very substantial task to prepare a review application, as we can see from the papers.
Yeah, when did they take this resolution? I'm just checking my notes. Didn't they take a resolution? When, yeah, maybe you can assist the court, but I suppose maybe one of the applicants may just deal with it. Am I right? There was a resolution taken sometime by the applicant.
Is your ladyship talking about the
Proposed.
resolution on the 24th of November 2020?
It's 2020?
Yes.
Yeah, I can't find it in my notes now. That what was that resolution?
It said if the appeals in relation to the impugned decisions are unsuccessful, it would be necessary to institute review proceedings to prevent the proposed development from continuing.
Yeah, what was that date, 2020?
That was on the 24th of November 2020.
Yes. So I think one of the respondents take issue with that date and saying since that date already, the applicants knew and were aware of their duty to take decisive action at some stage, but they
It's-
waited on water license,
Well-
on the water use issue to be resolved before they took action.
They had to go through the appeal processes. It was appropriate to wait for those to be completed.
Yeah, the
They
court-
would not have the resources
Yeah.
to start a preemptive review application, not knowing what the outcome of the appeals would be. They had to wait for the municipal planning process, appeals process to finish as well.
So their legal advisors told them that they may have difficulties if they proceed with the action prematurely.
Indeed,
Or what was considered to be prematurely. I
Indeed.
took note of those submissions.
indeed.
So on the applicant's version, they took action at the appropriate time.
Indeed, my lady, particularly when compared with what the statute permits,
Yes,
what the legislature has said is the appropriate period, and how it interacted with the decision-making around the water appeal and the
Yeah.
commencement of the development. At the end of the day,
so the water appeal was pending. And then the minister intervened.
The minister lifted,
The minister lifted it, yeah. The minister
lifted
intervened.
the suspension.
And that resulted in the commencement of the project.
Indeed,
Is that the position?
indeed, my lady. But as I say, obviously they had been preparing the application before then, but certainly at that stage they had to get a move on.
No, the court is alive to the problems of the first applicant with regard to finance as well as council, etc. Yes, now the court will hear what the respondents have to say about that, because some of the respondents dealt with that aspect quite seriously.
As the court pleases.
Yes. Thank you. You may proceed.
Now, I assume the court is not taking a tea adjournment, lady.
I don't know if anyone urgently needs an adjournment, they can just give the court an indication. Yeah, but I've given an indication. If you must come back Saturday morning, so be it. We can come back Saturday morning if any of the other parties didn't get an opportunity if we cannot conclude the arguments on Friday, the court is happy to come back on Saturday morning. But the court will, if any of the parties give an indication, the court will take an adjournment, but the court will continue with your submissions, hearing your submissions at this stage.
As the court pleases. If I may come back to the review component of the argument, lady. What we submit, this is at page 18 of the notes, lady. We submit in paragraph 39 that the wording of section 38.3 gives a broad discretion to the Heritage Resources Authority as to the information it may require to be provided. We say this because it goes on in a proviso to lay out the minimum information that must be called for, and we've been through all of those. and we've been through paragraph 40, I beg your pardon. And we've dealt with paragraph 41. We've dealt with the exception in paragraph 42, and we were looking at paragraph 43, where I've set out separately what the two components are, and in relation to the proviso to section 38. And importantly, they commence with the word must. So the consenting authority, in other words, the director and then the minister, must ensure that the evaluation of the heritage impact fulfills the requirements of the relevant heritage resources authority in terms of subsection 3, and again must ensure that any comments and recommendations of the relevant heritage resources authorities with regard to such development have been taken into account. And we make submissions in paragraph 44. It's peremptory. It's in peremptory terms because the legislation acknowledges the expertise of the statutory heritage authority and wants it to play out in the assessment as to whether or not the development should proceed. Because it is in peremptory terms, any non-compliance results in nullity of the affected processes. It creates two distinct obligations. The first binds both the heritage assessment practitioners and the decision-making authority. In other words, the practitioners must comply with the requirements stipulated by the Heritage Resources Authority under section 38.3, and the decision-making authority must ensure that the practitioners do so. Important here is that section 38.3 also includes its own mandatory component, which would apply and bind the heritage practitioners and the decision-maker regardless of what the Heritage Authority requires. It says that the information stipulated in paragraphs A to G must be included, again using peremptory wording. The first part of the proviso does not include any words that would confer any form of residual discretion on the authority deciding whether or not to allow the development to determine the extent to which the duty is to be fulfilled. So, for example, it does not read, the consenting authority must ensure that, in his or her opinion, the evaluation fulfills the requirements of the relevant Heritage Resources Authority. Those words are not there. That puts it into the category of an objectively justiciable obligation under the legislation that this court has the full power to examine compliance with. In making these observations, we do not suggest that it is the Heritage Resources Authority that in the final analysis decides whether or not the requirements have been complied with. We agree with the respondents that that decision must ultimately be made by the NEMA decision maker, here the fourth respondent and the fifth respondent on administrative appeal. But this is subject first to a fixed duty to ensure compliance with the requirements of Heritage Western Cape and section 38.3, and second to an objectively justiciable judicial review. So, in paragraph 46, the heritage should say the heritage assessment practitioner must fulfill all the requirements stipulated by the Heritage Resources Authority, must comply with A to G. He or she has no choice in the matter. The NEMA decision maker must get that right. They must correctly assess whether or not the heritage impact assessment has fulfilled the requirements of the Heritage Resources Authority in terms of subsection 3 and of the provisions of paragraphs A to G themselves, by providing the required information. If not, they must ask the assessment practitioner to provide what is missing. The way the NEMA decision maker can ensure that the impact assessment is compliant with the first two of the requirements. Sorry, that way. Next, the NEMA decision maker must ensure that the comments and recommendations of the Heritage Resources Authority are taken into account. The American Heritage Dictionary defines these words as take into consideration or allow for. Considering the first part of the proviso, it would seem that the second part of the proviso would require considering comments and recommendations that are distinguishable from the information requirements, which are what is required under section 38.3. This would seem to require, in the main, taking into account Heritage Western Cape's overall assessment of the heritage resources and the desirability of allowing the overall project to proceed. Next, the NEMA decision maker must make his or her decision on whether or not to allow the development. In making her decision on the basis of the compliant heritage impact assessment, it is the NEMA decision maker that determines how the information, comments, and recommendations in the compliant heritage impact assessment are weighed. It is within his or her discretionary remit, but subject to, we say, compliance with the general principles in section 5, the clear message inherent in the legislation that the requirements, comments, and recommendations of the Heritage Authority are to be given considerable weight, having regard to their statutorily recognized expertise, and his or her acting in compliance with the precise wording of the legislation procedurally, fairly, reasonably, and rationally. So where the respondents complain that we are asking for an appeal and not a review, we say they are quite wrong. What we say is that the difficulty that the respondents face in this matter is that the director, as well as the minister on appeal, were faced with a non-compliant, defective heritage impact assessment. Instead of insisting that the developer correct and supplement the heritage impact assessment so as to render it compliant with section 38(3) and 8, they proceeded to approve the development on the basis of a non-compliant heritage impact assessment. What is more is that they did so after the director had recognized, and we will come to the letter that shows that, after the director had recognized that there was non-compliance and had called upon the developer in terms of the first part of the proviso in writing to remedy the deficiencies in the assessment. This rendered their decisions unlawful and void. We then deal at page 24 with the environmental...
But the developer did file a supplementary report.
They did file a supplementary
Yes, they
report, and we analysed that supplementary
Yes.
report in detail to demonstrate why it was non-compliant.
And the applicant says it wasn't sufficient compliance. I was just having a look at the city's heads, because if I can recall, I couldn't find it now in the heads, but having read the papers, I think ultimately the HWC, after recommending consultation with the First Nations, that interim comments, once the supplementary report was received, did the city have problems to engage HWC at some stage? Because I think the city alluded to the decision makers, one of the decision makers had problems to deal with HWC. They're not a party here, but it appears that the applicants are relying on many of their views expressed in this matter. What was the problem with HWC at the later part of the process?
So, lady, again, yes, indeed, there was a workshop and there was a meeting that
Yes.
the interim assessment committee declined
Yes.
to attend. But again, if your ladyship will allow me to develop the argument.
No, but I need to pause there, because I hear you when you say you want to develop your argument, but I'm just busy considering one issue here with the HWC. You can refer to their views, and the court is very much aware of their views and their recommendations. But what happened at the end when the city wanted to engage HWC? What happened there? Because they're not a party to the proceedings. I'm asking the applicant.
Yes, they, as I said, the interim assessment committee didn't attend a workshop on the 4th of
Yeah.
March, and they didn't attend a meeting on the 10th of March.
The meetings, yeah, they didn't attend, and what were reasons given for not attending? Was it on more than one occasion, if I'm not mistaken?
Well,
What happened?
we deal in the replying affidavit, and I'll give you the reference, with what we can only surmise were some of the reasons. But no,
I see.
we don't have insight into that.
Yeah, the applicants, the court should not be posing the questions to the applicants.
And indeed, lady, it
But the
shouldn't be
applicants
lady.
went to HWC and had a meeting with them, an online meeting. So, but it is correct that the city had problems and the HWC
Well,
didn't.
I don't think it's the city so much as I think that took place under the auspices of the province.
Oh, yes.
And I think it was a meeting that it was convened by the war room of the premier.
Yes, yes.
But what I will say already at this stage is what was envisaged was some sort of a mediation process, it
Yes.
seems, under the auspices of the war room. And there's no provision for that in the statute. The statute doesn't
But
allow
mediation
for a
can
procedure.
happen any time if the parties agree to it, I would imagine.
Well, it would seem so. But
Mm-hmm.
again, if one looks at the background to what preceded that, I think one can get some sense of what the reasons were for their
And yet the
non-attendance.
HWC is not here today.
And they're
The
not here today.
HWC failed to attend a meeting or meetings. The respondents will perhaps address that, but I noted that they failed to attend one or two meetings or approaches made by the respondents. And was it just left there? there were no further engagement. What happened?
Well, there were no further engagements, and what should then have happened is that the letter of the 17th of February from the director should have
Yes.
been responded to, and they should have done what they were required to do, but they didn't. And effectively, they decided to push forward with the application, and the application was granted.
So Heritage
That was-
Western Cape's view was that it does not matter what we're saying anymore. They are going to persist with this development.
I can't really speak for what Heritage Western Cape ultimately, what was ultimately their view, save to the extent that they did in fact lodge an appeal against the decision. So I
They
suppose their position would
But
be.
they practically withdrew from this matter on the basis that the respondents have made up their minds. Isn't that so? They felt
Well-
there was no need for them to participate further in
They-
further meetings because according to HWC, the respondents made up their minds and there's no way that they could meaningfully participate.
Well, what
in this matter.
HWC said is that we've made our position clear. And
Yeah.
with respect, it is clear. If one looks at those letters, one can see what the problems are.
But the
And-
minister, I don't know who it was now. One of the respondents could not complete any meaningful engagement with the HWC. Because what happened there, I'm just engaging the applicant on that. The HWC decided not to engage further, notwithstanding requests to engage further. Isn't that so?
Well, there was a subsequent exchange of correspondence
Yes.
as well, I think with the minister, if I remember correctly. And they said, we've made our position clear. Here, there are 2 letters in which we set out our requirements. Those are our requirements. And they have the statutory function under Section 38.
And they refused to engage further.
3 to do that. Well, we just know that there wasn't, that they didn't attend the meeting on the 10th of March.
And based on that, certain decisions were then subsequently made.
Indeed, milady, and we will deal with the difficulties because it involved a volte-face on the part of the minister and the director, because they had recognised that there was outstanding work for the developer to do, and then they changed their mind about that, and we say that was unlawful. Milady, if I can then continue at page 24 of the notes. We don't need to traverse the EIA aspect of the heritage impact assessment. It's essentially common cause. But there is one aspect of the regulations that does require emphasis, and that is this. There are 3 potential outcomes to a development application. It can be refused, it can be granted, or it can be granted with conditions. The function of the specialist heritage impact assessor is to provide a report which forms the main source of information and professional guidance for the decision-making authority to decide between those 3 options. This is borne out by item 31P of Appendix 1 and item 11N of Appendix 2.
Option was then, it was granted subject to conditions. That is what happened.
Indeed,
Yeah.
indeed, lady.
Yes.
So, if one looks at item 31P of Appendix 1 and item 11N of Appendix 6 to the EIA regulations, they require an EAP and a specialist reporting on impact assessments, amongst other things, to provide in the wording of Appendix 1 and as one of the concluding items, a reasoned opinion as to whether the proposed activity should or should not be authorized, and if the opinion is that it should be authorized, any conditions that should be made in respect to that authorization. What is apparent from this is that it is one of the duties of the consultant preparing the impact assessment to give very careful and serious consideration and advice to the decision-making authority on a refusal of the development application as one of the potential outcomes. And as one can imagine, that is obviously not going to be a potential outcome that is attractive to the developer that is paying them for their services. And for that reason, we point out that conducting an impact assessment and reporting on it requires a fiercely independent mindset on the part of the consultant. This is borne out by Regulation 13.1a of the Environmental Impact Assessment Regulations, which especially requires that, quotes, an EAP and a specialist appointed in terms of Regulation 12.102 must be independent. There is also a specific definition in the EIA regulations of the term independent, and it lists what they must not have, such as business, financial, personal, other interest in the activity. And then in the B of the definition, there are no circumstances that may compromise the objectivity of the EAP specialist or person in performing the work. So we then examined page 26 and following, what were the requirements of Heritage Western Cape in terms of the proviso in section 38.8? What exactly were they asking for? And those are apparent from a letter addressed by the Chief Executive Officer of Heritage Western Cape to the first respondent on the 13th of September 2010. It's Annexure LL10. This was its response to what it described in the papers as the developer's second Heritage Impact Assessment, dated 2 July 2019, prepared by Hart and Townsend. The letter is helpful in that it crystallizes Heritage Western Cape's requirements in direct response to the listed items, those paragraphs A to G.
But my impression is that the city says that Heritage Western Cape did not provide any content to what they required. That is my understanding.
So
Heritage Western Cape, at the end of the process, Heritage Western Cape practically withdrew from the matter, but did not give any content to what exactly is it that they require when they were asked to come to the meeting and please come and explain. Is it so that Heritage Western Cape didn't explain exactly what they meant by what else should be done?
We submit that what they did was certainly clear enough.
But you can say there's non-compliance with 38.82. You can say that, but you still need to explain. This is a big project. Provision is made for various components in this project. Low-income housing, infrastructure, river rehabilitation, the eco-trail, accommodating First Nations in one portion, having this pedestrian area which the River Club never had.
Lady,
But HWC never explained what can be done.
we submit that they didn't, lady, and if one looks at the...
Where will I find that?
Well, it's
they were called to a meeting because further engagement had to take place with the decision maker, and the decision maker was not provided. You refresh the court's memory, you say it's one of the ministers. Things were just left there. It was just Heritage Western Cape made recommendations, consult with First Nations. You didn't comply with 38.8. Whatever, there was non-compliance, and whatever they proposed, they failed to contextualize it. Maybe that's a better word. They did not contextualize it. Are you saying they did?
Well, we say it was clear enough from those letters, milady, and we, if I can start by referring you, we in the founding affidavit teased out what the requirements were in relation to each of those. Those are set out at page 72.
So are you saying the environmental assessment
70
should not,
to 75.
Environmental approval should not have been given, notwithstanding the fact that HWC practically withdrew from the process? Am I wrong if I say that? That they practically withdrew and just sent a letter and said, look, our views still stand, we're not attending meetings, and we are of the view. That is my impression. I'm engaging the applicant on this. HWC said, we still stand by our first submissions or first comments, because they are there to comment. It looks like the parties are in agreement there. But they did not participate further at some stage.
Well, lady,
saying there was non-compliance, it still stands, but they did not contextualize it. Am I wrong if I say that?
Well, lady, there can be a debate about perhaps the full range of what was contained in those letters, but there were some things that came out of it very clearly that were not complied with.